Hi, everyone. I'd like to just thank everyone for joining us today with the Ontario Public Works Association and our Public Works Connects. Before we begin with our talk, I would just like to provide a little bit of information about OPWA. My name is Trisha Hamilton. I work with OFN-TSC, and I'm the Education Chair of the OPWA. So OPWA, the Ontario Public Works Association, is a not-for-profit association of public works practitioners. The Ontario chapter is one of the chapters that make up the American Public Works Association. We have over 500 members who are employed by governments, municipalities, consultants, utility companies, contractors, and suppliers. The Ontario chapter also has two regional branches, including the West Central branch in the Niagara region and the Ottawa Valley branch in the Ottawa area. Our mission statement reads, supporting the public works community. OPWA provides its members with opportunities to connect through workshops, conferences, and social events. Another great way to stay involved is to volunteer for one of our 9 committees that you can see along the right there. And we're always looking for volunteers, and your creative ideas are wanted. If you're not a member of OPWA, we encourage you to take a look at our website and to consider joining. We do have some upcoming OPWA Connects webinars, including one planned for April 23rd. So again, we encourage you to keep an eye on your emails if you're interested in some of these potential talks. We're also, from the Education Committee, always looking for presentations that are relevant to public works in Ontario. So if you have any proposed topics, please feel free to send an email to info@opwa.ca with the potential talk. We do have some upcoming events with OPWA, including the National Public Works Week, the Project of the Year Awards, our Golf Day, and the York Region Pride Parade. So again, encourage you all to take a look at our website and to write down some of these exciting dates that we have upcoming. For today's webinar, just a few housekeeping tips. So all of the attendee microphones have been muted and cameras will remain off. We encourage questions, so if you have any questions for our speaker, please write them in the Q&A box during the webinar, and then at the end of the talk, our speakers will go through and respond to some questions. And just another note too, that this presentation is being recorded and will be available on our website. So with that, I'll introduce our speakers today. So Jeff Scorgie is a partner in the construction practice group at Weirfolds. Jeff's practice is focused on drafting and negotiating contracts and advising on other front-end aspects of construction projects, including procurement and tendering. Jeff co-chairs a popular webinar series focused on practical insights and tips for those in the construction industry, and he previously served as an instructor for the Law and Construction Contracts course at George Brown College. Kathleen Gregus is an associate in the construction practice group at Weirfolds. Kathleen has experience reviewing, drafting, and negotiating a wide variety of construction contracts and providing strategic advice on procurement processes. Kathleen is actively involved in the Canadian Association of Women in Construction. Both of Jeff and Kathleen's clients include owners, developers, contractors, subcontractors, suppliers, and consultants at various stages of contractual disputes. And with that, I'll now turn this webinar over to Jeff and Kathleen.
That's great. Thanks, Trisha. And thank you, everybody, for joining us. It's great to be here. So we're going to be talking about the Construction Act and focusing on some of the new changes that have been made to the Act and that will be coming into force at some point, likely this year. And so we want to just start by providing kind of just a refresher of the timeline for how the Construction Act got introduced into Ontario and the changes that are already in force. So for the longest time in Ontario, we had the Construction Lien Act, was what it was initially called. Then in 2016, two construction lawyers were hired to essentially conduct a review and audit of the act and speak with industry and try and figure out, determine what needed improvement, what was wrong with the act, what wasn't working. And so they produced this report called Striking the Balance. That was in April of 2016. Then, based on a lot of those recommendations, the new Construction Act was passed in December 2017. And it came into force really in two tranches. So the first tranche came into force in July 1st of 2018, and that was changing the laws and the rules dealing with construction liens, primarily substantial performance and holdback. And then the second tranche came into force in October 1st, 2019, and that involved the introduction of the prompt payment rules and adjudication, the statutory dispute resolution process. So that was where we sat up until very recently. Now, one of the recommendations, in fact, the last recommendation in that striking the balance report from 2016, recommendation number 100, was that the act be reviewed again in 5 years of the enactment of the act to see again how everything's working, what's not working, or can any improvements be made, and that sort of thing. So we're now at that point in time when the act was recommended to be reviewed and reconsidered, particularly the new amendments that came into force in 2018 and 2019. And so that's exactly what happened. Construction lawyers and the construction industry were consulted. A number of issues were identified with the Construction Act, and in particular, the Construction and Design Alliance of Ontario and the Council of Ontario Construction Associations prepared a very substantial report that basically, as we say here on the screen, looked at what were the gaps, what are some inconsistencies, again, problems, what's not working with the Act. And that resulted in a very significant report that was delivered. And then the Ministry of the Attorney General hired a construction lawyer, Duncan Glayholt, to produce a review, which he did, and that's called the Ontario Construction Act Review. And that recommended a number of further changes to the Construction Act. And so this is kind of the timeline of the amendments that brings us here to today. So you can see there on the screen in February of 2024, that's when Duncan Glayholt was appointed to do this review. There was a consultation process with the industry that happened over the summer of 2024. Glayholt's OCAR final report was released at the end of October of 2024, and then that resulted in the amendments being drafted and receiving royal assent in November 6th of 2024. So that takes us up to today. So we have now a set of new amendments to the Construction Act. In terms of when they are going to come into force, we're not totally sure. We don't have an exact date, but they are ready. They are ready to come into force. I think the intention was that they were going to come into force earlier, but because we had an election in the province, things got a little bit delayed. So my suspicion would be they will be introduced probably sometime later this year. And so that's what we're going to talk through today. Or we're going to go through cover the main, most impactful changes and kind of look at how they're going to impact the industry, your organizations, your contracts, and your projects, as well as procurement practices and methodologies as well. So Kathleen, do you want to get us started here with part one?
Yeah. Hi, everyone. Thanks for having us. So as you'll see on this slide, part of the first tranche of changes that Jeff mentioned in the previous slide was changes that changed the way lien periods operated. So they extended the lien period from 45 days to 60 days. They introduced new termination of contract provisions. They introduced mandatory release of holdback, as well as optional annual and phase release of holdback. They added provisions dealing with P3 projects. There's also mandatory bonding at 50% bonding for public projects above a certain contract price, and also introduced enhanced trust provisions. So these are some of the main changes that came into effect in 2018. And they set the stage for what we're talking about today. So one of the main issues with the Act as it exists, or as we've been operating under for the last number of years, is this definition of contract price. And in the Construction Act, this definition of contract price is quite significant because there's certain thresholds that turn on this definition. So for example, the mandatory bonding requirements turn on this definition of contract price. And this definition is problematic because for one reason, there's certain project delivery models that are used really frequently throughout the industry that don't actually have an initial fixed price at the onset of the contract. So it makes this definition and applying this definition really problematic. So these delivery models are some that many of you would be quite familiar with. So construction management contracts, cost plus contracts, integrated project delivery models. In all of these circumstances, the definition of contract price doesn't work very well. And so how this has been addressed, or how this is being addressed, is the introduction of a new definition of contract price. We don't know what that definition is exactly yet because that will be introduced through the regulations. But we can speculate that this new definition will be tailored to address those types of delivery models where there's no fixed price. So we presume that it will likely be aimed at addressing or dealing with delivery models that there's no fixed price, but looking at what the anticipated contract value will be. So that's our assumption.
That's right. And now one of the other significant areas that is being changed in the new Construction Act is dealing with how lien rights work for those performing services before construction starts. And this has been a problem stretching back to the original Construction Lien Act. So the original wording of the Construction Lien Act, you can see there on the screen, states that when the making of a planned improvement, an improvement in the Construction Act lingo and jargon is essentially synonymous with project. So when a project has not started, the supply of a design plan, drawing, or specification that enhances the value of the owner's interest in the land constitutes a supply of services, and that therefore means if you have, another way to put it is if you've prepared designs or plans that can be said to have somehow enhanced the project owner's interest in its land, you have supplied services to an improvement, and therefore you have lien rights. And this also means if you have lien rights, that the 10% holdback should be retained from you. But this was a little complicated to implement in practice. I think there's often a disagreement or there's confusion. People simply don't know, is what I'm doing as a designer, as a consultant, maybe as a construction manager performing pre-construction advisory services, is what I'm doing enhancing the owner's interest in the land? It's not a very easily workable definition under the Construction Act. And therefore, what we saw across the industry was a lot of project owners not being sure whether they should be retaining that 10% lien holdback, particularly from design consultants. Now, a lot of public owners and private owners, for that matter, have just kind of made policy decisions one way or another, saying, yes, we are going to make the decision to retain 10% holdback from all consultants, or from at least these types of consultants, designers, architects, engineers, maybe not some others. But it's not, from the Construction Act's perspective, it's not totally clear crystal clear whether you have lien rights if you've performed services before construction actually starts. So what the recommendation was that this wording around the concept of pre-improvement services, that's really what we're talking about, pre-construction services, should be clarified. And so that's exactly what's happened. What we're now going to see in the new act is that the new rule is going to be that if a project owner decides to retain holdback, the 10% holdback from a consultant, right, prior to the start of construction, then those services, that design work, is presumed to enhance the owner's value in its land. And therefore, the designer is presumed to have lien rights unless the owner can prove otherwise. So essentially what's happening here is the Construction Act is now going to say effectively, okay, project owners, if you're going to retain 10% holdback from your design consultants, we're going to assume they have lien rights, unless the onus is now going to be on the owner to prove that the work product, the services that the designer performed or provided do not enhance the owner's value in the land. So what this really is going to do is, it's going to be particularly important for project owners to kind of reconsider internally their policies and practices around retaining holdback from consultants. And they now really do want to carefully consider, should we be retaining holdback? Because by retaining holdback, we are basically, it's going to be presumed that the consultant will have lien rights. So that's how the new Construction Act amendments are trying to address the issue of pre-construction services, pre-improvement services.
Okay, so in 2018, when the Act was amended the first time, it introduced the concepts of when a prime contract is terminated, either the owner or a contractor or another person whose lien is subject to expiry must publish a notice of termination in a trade newspaper, a common one being the Daily Commercial News, for example. And this is really important because the 60-day lien expiry period for a terminated contract is triggered upon completion of the contract. The problem, though, was that the Construction Act, as it was amended in 2018, didn't specify when the notice of termination had to be published. And so that led to situations where parties were waiting a really long time to publish their notices of termination. And in some cases, that meant that by the time the notice of termination was actually published, the lien rights for subtrades or subcontractors had already expired. And so it was really good intention to have this requirement that they post a notice of termination, but because of that gap, it wasn't effective in a lot of cases. And so what they've done with the new amendments is introduce a requirement that a notice of termination has to be published within 7 days after termination of the contract. And it's also been clarified that the lien periods for everyone start at the date of publication of the notice. And so the idea is really that these requirements are designed to not have the lien period trigger until subcontractors are actually aware of the termination through publication, which before now they might have been wholly not aware of.
All right, so now we're going to talk about holdback, and I think this is probably one of the most significant changes in terms of its impact to the industry that is being introduced as part of the new Construction Act amendments. And there's a few parts to this, so we'll kind of just take it in pieces. So the first is dealing with the concept, the topic of mandatory release of holdback. So the original wording, the current wording in the Construction Act right now says that holdback shall be paid when lien rights expire downstream. So, if we take the perspective of the owner and its general contractor, so the owner will is required to release the 10% holdback to its general contractor once all the lien rights of the general contractor and all of its various subcontractors and subcontractors and so on have expired. Now, the problem is that the Act doesn't say when the holdback payment has to be made. It just says that once the liens expire, it shall be paid. But it doesn't clarify how long. So owners theoretically can, and we certainly are seeing that in the industry and have seen this since these changes were made in 2018, sitting on the holdback, right? And so they can comfortably say, yes, we are going to release it, but exactly when, that's not totally clear. The Act also doesn't say how the holdback is to be paid, in terms of from the owner to contractor, from contractors to subcontractors. So it's quite unclear on these points. Now, what the recommendation was is to essentially that there needs to be a payment cascade for the release of holdback monies, just like the prompt payment rules, which we're going to get to in a second. That's kind of the part two of the changes. But in the prompt payment rules, there's this kind of cascading chain of payment obligations from owner to contractor to subcontractor to subcontractor. And so that's now exactly what they've introduced with holdback. So now, under the new act, the payment of holdback must be made by the owner to the contractor within 14 days after the liens expire, or if they're, if liens have been registered on title, for example, or they've been delivered in the case of a public or municipal project, after the liens have been cleared, so after they've been vacated by the posting of security. And then similarly, the contractor will have to pay its subcontractors within 14 days after receiving the holdback from the owner, and so on. Everybody down the construction pyramid has to pay those below them within 14 days of getting the holdback from the person above them. So this is this is going to be a significant change. Owners are now not going to be able to just kind of sit on their hands and sit back and not release holdback. There's going to be a clear provisions in the statute that require exactly when the holdback is going to have to be paid. And as you can see, it's going to be quite quickly, 14 days after liens expire. So again, just putting this into practice on, say, on a normal project, your prime contract between the owner and general contractor will achieve substantial performance. The certificate of substantial performance would likely get published in something like the Daily Commercial News or Link to Build. And then that triggers the lien expiry period of 60 days. And then after that 60 days expires, the holdback will have to get released within 14 days. So it's establishing a clear series of timelines for the release of holdback. Another change dealing with holdback is annual release of holdback. Again, this is going to be another very significant, very impactful change to the industry. So originally in 2018, one of the changes that was made was there was kind of a recognition that the Construction Lien Act's rules around holdback, retention, and release were outdated and not suited for longer, larger projects where, holdback was being retained for very long periods of time. Projects could, span multiple years, and the holdback system just wasn't working. It was too punishing, particularly for sub-trades who are involved early on in the project, and then their work is finished and they don't get their holdback released for potentially years later. So there's been a recognition that this has been a significant problem in the industry for some time, since the Construction Lien Act was reviewed with the Striking the Balance report back in 2016. So in 2018, one of the changes that was made was that there was this introduction of annual and phased release of holdback as two potential options that could be implemented in the prime contract. So in the contract between the owner and the general contractor. And basically, just like the phrases suggest, annual holdback would involve payment of holdback on an annual basis, and payment of holdback on a phased basis would be basically the parties would set out in their prime contract what the phases of the project were, so phase 1, phase 2, phase 3, describe what those are, and that holdback would be released as the phases get finished. So the idea is that you're not retaining holdback for the entirety of the contract duration. Now that seems like it was good, potentially a good solution. The problem in practice, certainly what we've seen since 2018, is that this rarely gets implemented for the simple reason that it needs to be specified in the contract. And there just really wasn't much incentive on project owners to be putting this in their contracts. What's really the incentive for a project owner to be agreeing to annual or phased release of holdback in their contract if they don't have to? And so we just haven't seen it happen really in the industry. So we really didn't get much further ahead. Also, the act didn't allow for subcontractors to have rights to information about the contract terms in this respect. So, you know, a prime contract may allow for phased release of holdback, but how would a subcontractor even know if that's the case unless they've been provided a copy of the prime contract from the general contractor, which does happen sometimes, of course, but not always. So that was another shortcoming. So what we're now going to see is there is now going to be mandatory annual release of holdback on all contracts that are over 2 years in length. So this is going to be very significant. There's going to be a notice of intention to release holdback that now has to be published by the owner. And so these were the two recommendations. This is exactly what we've seen. So mandatory release of holdback on all contracts that are over 2 years. We have a slide diagram in the next slide that kind of we'll walk through the time frame of how this exactly works. But the annual date will be the anniversary of the date the contract was entered into, and then the publication of the notice will have to be within 14 days of that anniversary date. So how exactly does this work? So you have your contract. This is year one. And again, this is assuming your contract is over 2 years. If it's not, then this doesn't apply. But assuming it's over 2 years, then there is going to be this mandatory annual release of holdback. So year one happens, right? So that's your first anniversary date. Then within 14 days of the anniversary date, the owner has to publish its notice of annual release of holdback. And so it has to publish that in a manner like, currently substantial performance certificates are published. So in a construction trade newspaper like the Daily Commercial News or Link to Build. So that would get published. That will now trigger a lien period. And this is also going to be very important for the industry. So this triggers the lien expiry period for that year's worth of work. So that publication. So it's in effect, it's very similar to, it's like a mini substantial performance in that sense. So that period runs, and that's going to be 60 days, right? So a 60-day lien expiry period. So the owner is going to wait 60 days. Now, assuming no liens get registered or delivered, if it's a public job, assuming no liens get preserved within those 60 days, then the owner has to release the holdback that is accrued during that first year to the contractor, and they have to do that within 14 days. And then the payment cascade goes downstream, so the contractor then has to pay its subcontractors the holdback within 14 days of receiving the monies from the owner, and so on. And so then, we get to year two, right? This will be the second anniversary date here, and the same process starts all over again. And then eventually your contract is going to finish, right? So eventually you'll get to substantial performance, and that's going to be a stub year, right? Because you will have released the holdback for the previous full calendar year. And then you hit substantial performance, and then the same process that has existed under the current Construction Act regime will apply for substantial performance. So that still all happens. Certificate of substantial performance gets published and all of that. So that's the annual release of holdback system in a nutshell. I'm sure folks may have questions about that, which we'll be happy to answer at the end. But that's essentially how the system is going to work. The kind of final piece we just want to flag for you on the issue of holdback is the notice of non-payment of holdback. So the previous amendments in 2018 basically said that they introduced the requirement that an owner shall release the holdback after the lien expiry period unless it published a notice of non-payment of holdback. So it would appear, based on the current statutory system, an owner can refuse to release holdback simply by publishing a notice of non-payment of holdback, which basically defeats the entire point of having a mandatory release of holdback. So what was the solution proposed to that? It's just getting repealed. So there will now be there is essentially no ability for an owner to refuse to release holdback to a contractor now. So it took 2 tries, but now finally the legal system in Ontario now has true mandatory release of holdback. So as I said, I'm sure there's some questions on that, but happy to answer them. at the end. And sorry, the last point I forgot to mention is that concept of phased release of holdback is now also getting repealed. So there'll be no ability to have a phased release of holdback. But again, it's now going to be replaced by this concept of mandatory annual release of holdback.
Okay, so the second part that we wanted to talk to you about, or the second big batch of changes relate to prompt payment. As many of you are aware or partially aware, in 2019, in October, various changes were made which introduced the prompt payment regime in Ontario. This regime essentially legislated payment timeframes for parties on construction projects, which was novel. We didn't have that before. And so some of the key features of this regime that we operate under now is that the owner must pay the contractor within 28 days of receiving a proper invoice. The owner has 14 days to give a notice of non-payment if they dispute any amounts. The default invoicing period is monthly, but it can be done on a milestone basis if parties want. And contractors must pay subcontractors within 7 days of receiving payment from the owner, and so on down the subcontracting chain. And so prompt payment wasn't just meant to stipulate timeframes for payment. Really, one of the most important features of this system is in the last bullet on the screen, and it specifies that if a contractor does not receive payment from the owner, they must still pay the subcontractor or undertake to adjudicate with the owner. And so the central issue that prompt payment is really designed to address were situations where subtrades had performed all the work on a project, had done it well, and done it properly, and then because of some upstream payment dispute, they were going unpaid. And so prompt payment is meant to facilitate the flow of money through the construction pyramid and to address the pay when paid system that we had been operating under for so long before. And so what this means is that contractors must provide a notice of non-payment form in the prescribed form under the Act, which includes an undertaking to commence an adjudication with an owner within 21 days of delivering a notice to a subcontractor if they are not going to be making payment. And so we'll see on the next slide that one of the most critical features of this system is the proper invoice. And so this is really the key document in the prompt payment regime. With the delivery of a proper invoice, that's what triggers this cascade of rules established in the prompt payment regime. And if the proper invoice isn't delivered, then the rules of prompt payment aren't triggered. And so at minimum, a proper invoice has to include all of the items that are included at Section 6.1 of the Construction Act, and we have them up on the screen for you now. You'll see that some of them are highlighted, and we've highlighted these because when Jeff and I are reviewing templates for proper invoices, which we do frequently, these are items that are often missed or not included properly, which means that when parties are submitting their invoice, they're actually not a proper invoice. And so what has been done with the new amendments is they have changed the requirements for what is included in a proper invoice to try and encourage greater compliance. So because of the specificity and the really narrow nature of some of those requirements, they were getting left off inadvertently. And so now these requirements have been revised. And another problem another issue that we have currently or have had currently is that even though there was a requirement that a contractor submit or a subcontractor submit a proper invoice and that the owner has to pay it within 28 days, there was no requirement on an owner or a payor generally under the Construction Act for them to give notice to a payee that their invoice was improper or not compliant with the Construction Act. And so we had lots of situations where a contractor, for example, would submit an invoice. They would think that it was a proper invoice at the time of submission, and then 28 days would roll around and they would not be entitled to payment because they had not submitted a proper invoice. And so now what the most recent amendments have done is introduce a requirement that within 7 days of an owner or payor receiving a proper invoice, they must give notice of non-compliance if it is not compliant with the act or the requirements that the parties have agreed to under a contract that are required for a proper invoice. They have to give notice within 7 days, or else that invoice will be deemed to be a proper invoice. And so this is the solution that they've come up with to try and address this, this problem.
All right. So the final batch of changes relates to big changes. It relates to adjudication. And so just a quick refresher on adjudication. So adjudication was introduced alongside prompt payment as part of the October 2019 amendments to the Construction Act. And it is really a statutory dispute resolution process that is intended to settle in-project disputes. So, over things like payment disputes, disputes over the values or quantities of work performed, disputed unapproved change orders, or the failure to release holdback. And it was really introduced as a way to, again, settle in-project disputes in a manner that is far more quick than litigation and arbitration, which are the two kind of default methods of resolving disputes in the construction industry. And if any of you have been involved in litigation or arbitration, you know that it is a extremely long and expensive process for resolving a dispute. And so the idea was that adjudication would be quick, kind of like a rough justice that could happen during the course of the project, and so that the project could continue on and not get bogged down by some extremely lengthy, extremely costly dispute resolution process like litigation. And so our adjudication system that was introduced in Ontario was adopted very much after adjudication in the UK, where they've had it for a few decades now. And the essential pieces of it, again, some of you may have been involved in one or more already, but at a high level, disputes would get resolved by an adjudicator within 30 days. So you would appoint your adjudicator. So a party could commence an adjudication by delivering a notice of adjudication. If the two parties can't agree on an adjudicator within a few days, then the body that governs adjudication in Ontario, which is called ODAC, would appoint an adjudicator for you. Again, this is all going to happen in a few days' time. It's quite quick. And then as soon as the adjudicator is appointed, they have to render their determination within 30 days. Now, there is an ability to extend that time frame, but they can't do it without the party's consent. So sometimes it gets extended if it's a more substantive, more complex adjudication, but still, we're talking 30 days, maybe 45 days, maybe 60 days, but we're not talking years, which is the reality of litigation and arbitration. The determinations that are issued by adjudicators are interim binding. That's what we like to refer to them as. So essentially means they're binding until changed by court or arbitration. So they're binding on the parties, but you're still free after the determination to still go off to court and relitigate the issue if you want. And if you do, the ultimate court judgment that comes out of that litigation would trump the adjudication determination that was issued during the course of the project. But if that never happens, the adjudication determination is binding on the parties. And there's a lot of teeth to these adjudication determinations. If they're not paid within 10 days, then the winning party, say it's the contractor, they actually have a statutory right under the Construction Act to suspend work, to demobilize, to down tool, and they'll be entitled to the costs associated with resuming work and their suspension costs. And the adjudication determinations are also enforceable like a court judgment. So you can just take it and run off to court and get it enforced like a court judgment. And then you could potentially go off to the sheriff's office and get the loser's property seized and sold. So it is a very powerful system. And again, it's kind of rough justice. It's fast, and that's what adjudication was. That's what we've had since October 1st, 2019. In terms of what can be referred to adjudication, there's 6 the categories, which are called matters under the Construction Act, non-payment being one of them. But some of them are phrased a little unclearly, and it's not completely clear exactly the scope and breadth of the types of disputes that can be referred to adjudication, which I don't think was the initial intention by the legislature when they drafted it. So what we're going to see is that the matters that can be adjudicated are going to be clearer. Now, this is going to be set out in the regulation, so we don't exactly know quite yet how they're going to change this, but we have every reason to believe that certainly the intention is going to be broadening the jurisdiction of adjudication so that it really can cover the kind of main key types of disputes that you have on a construction project that would arise in the course of the performance of a construction contract. Another kind of wrinkle or problem with adjudication is that currently it's not available to deal with disputes after the prime contract has been completed. And when we refer to completion under the Construction Act, that means that's defined as essentially being where there's less than $5,000 work left of incomplete work or deficiencies to be corrected. So that's problematic because, of course, most disputes, about things like change orders, certainly about holdback release, are going to occur right at the end of the contract. And so this has been a challenge because a lot of times a dispute will arise and then you'd want to refer to adjudication, but you can't because the contract has achieved completion. So that's been a bit of a challenge. And the Act was also silent about timing with respect to where a contract was terminated or abandoned. So it said, you can't adjudicate a dispute after a contract's been completed, but what if the contract's been terminated or what if the contract's been abandoned? The Act just wasn't clear on that. So the recommendation was that adjudication should be available for a little buffer period of time after a contract has been not only completed, but also terminated or abandoned. And so that's exactly the amendment that's going to be made, is that adjudication will now be available for a little window of time after a contract has been completed, terminated, or abandoned, which I think is a good change. And adjudication, another wrinkle was that it was not available to deal with disputes after a subcontract was complete. But this was confusing and complicated because, unlike prime contracts, there's no definition in the Construction Act for what completion of a subcontract means. There's no equivalent formula or way to calculate whether a subcontract has been completed or not. So how they're going to change this is now that adjudication is going to be available for 90 days from the earliest of the date the subcontractor last performed work on site, the date the subcontractor's subcontract was certified complete, rarely happens, but sometimes happens, or if the prime contract or the head contract was completed, terminated, or abandoned. So again, there's going to be this little buffer, this little window of time, 90 days after this period where a dispute under a subcontract will be able to go to adjudication. And so lastly, before going to some questions, we thought we should just briefly touch on the transition rules. So the Act is, as we said at the beginning, it's the amendments have been drafted, and we don't exactly know the date they're going to be coming into force. But when we do know, how is it going to come into force? Now, some of you may remember, if you were up to speed on the previous Construction Act amendments that came into force 2018 and 2019, the transition rules that govern that system is kind of a mess, to put it politely. It's very confusing. There's lots of disagreement over when the 2018 or when the 2019 rules have come into force. It all turns on the date of when the procurement process for the contract for the improvement was commenced. It's very confusing. What does for the improvement mean? There's been lots of disagreement in the industry around that. Currently, the most recent, been some recent case law that suggests that may turn on the actual very first contract associated with the potential project. So, like the first time the owner procured its design consultant for the project, that's what governs. Whenever that happened, that's what governs which version of the Construction Act you're under, which has led to a rather silly result where we're now seeing current projects ongoing that are still subject to the old Construction Lien Act. So suffice to say, the transition rules under the old Construction Act amendments left a bit to be desired. The transition rules, mercifully, for these new amendments are going to be much simpler. They're going to essentially apply immediately. So as soon as the Construction Act comes into force, the new rules are going to apply immediately, regardless of when your contract was signed or when the procurement process was started for your contract. They're just going to happen that day. The one exception to that is for the mandatory release of annual holdback that we talked through. So for that, there's going to be a 1-year grace period because there was a recognition that depending when your contract was entered into, that could be problematic if the new changes happen immediately, because that might mean you have to release holdback, the day after the Construction Act changes come into force. So for that one rule around annual release of holdback, there's going to be a 1-year grace period, but for everything else, it's just going to apply immediately. So that may, I think, create from a procedural kind of standpoint, getting up to speed, a kind of learning and education standpoint, that might be a bit challenging because everything's going to happen quickly. But I think from a kind of certainty standpoint, it is likely a bit better than the previous transition rules for the previous Construction Act changes. And then just lastly, before turning to some questions, we have here on the screen just a few of the other changes that are being made, kind of some other changes that are being made that we didn't dive into in great detail, but they're here on the screen. So there's some changes about joining trust claims and lien claims in litigation proceedings. You're now going to be able to adjudicate trust claims under the Construction Act. There's now going to be a database of adjudication determinations that can be referred to, similar to how court decisions are publicly available and can be referred to. There's going to be a variety of other changes as well. We won't get into all of them, but that's where we are with the Construction Act changes. So that's a kind of overview of all the main changes. Hopefully you found that helpful. And then, as we said, in terms of next steps, we're not exactly sure when the amendments are coming in force and when we'll be seeing the regulations. Again, I think our suspicion is that it'll be this year sometime, but again, we're not entirely sure. Could be this summer. That's probably that. I think that would be my guess, but we'll have to see. But they will be happening soon. So. Again, hopefully that was helpful. And now I think we can turn it over and to address some of the questions that have been put into the Q&A.
Yeah, sorry. Thank you very much, Jeff and Kathleen. I think that was very informative, and definitely the annual release of holdback is going to be a big change for everyone to wrap their minds around. And Jeff, we'd spoken before. I understand you have a webinar series, and you're giving a talk Thursday morning as well on tariffs, which we all know is a hot button topic, eh?
Yeah, yes. To put it mildly, that's right. Yeah. So, no, thanks, Tricia. Yeah, I do. We do run a regular webinar series in the spring and in the fall. It's called Tools for Success. You can find it online. We run it through our firm, Weirfolds, and we run it every spring and fall, and it's just on different Construction Act topics. We often will have guests from industry, and we really try to just cover issues that are important to the industry and really try to focus on kind of practical tips and insights to those in the construction and procurement space. So yeah, feel free to look that up if you'd like to. And as Tricia said, we do have one coming up on Thursday on tariffs. So which although you may be sick of talking about tariffs, so I don't judge you if you don't want to come to that one.
Okay, perfect. So like I said, we'd recommend if you have any questions to please add them to your Q&A box on your Zoom screen. Maybe just a quick question I had. So for the annual release of holdbacks, you're saying that applies for contracts that are 2 years and longer. What if the contract starts out shorter than 2 years, but then just gets extended? Do we know what happens then?
Yeah, oh, that's a great question. The short answer is no. So I will give you, we don't know I can't say definitively. I'll say, I think my, best educated guess is that if it does become longer, so if as a result of change orders, you have approved schedule extensions, then my reading of the act is that it's pretty black and white. It would apply. The annual release of holdback would apply. But yeah, certainly I can see how that would create some challenges, especially you can imagine a scenario where the change order that pushes the contract over 2 years happens right before the annual release date would be, then you might be scrambling to try and figure that out, in a few days. So that could get complicated from an administrative perspective, absolutely. But that's my best guess. I can't say a court wouldn't, disagree with me on at some point, but that's a great question for sure.
Okay, thanks. One of the questions we have, during the annual release of holdback, the 60-day lien period, do regular monthly payments go on hold?
No, they don't go on hold. So monthly progress payments would still, be made in the normal course. But what the question is touching on is another really important just piece of information that I think is sometimes lost when people are talking about these new Construction Act changes, and that is that the way the act is read, and I think certainly our interpretation of it is that although you're only, the owner is only releasing the 10% holdback, but the contractor's lien rights for not just the holdback, but for the entire work performed during that year expire. That's our interpretation of the act, and that will have significant, I think, repercussions. Unfortunately, that might result in more liens, actually, because if you have disputes over progress draws during that year, you may see contractors and subcontractors preemptively liening as a precaution because their lien rights would be running out. So that's a very significant issue that relates to kind of progress draws. But yes, to answer the question, no, progress draws would continue. The holdback kind of application and release of payment it's kind of a dual track system that would be happening on the side.
Okay, thanks. Another question is, if there's a disagreement on the quantity on a payment certificate, can the owner deem it not to be proper?
Another great question. So I think I would say my view of that is that in terms of whether an invoice is a proper invoice or not, you have to look at what do those requirements that Kathleen was talking about in the statute, those 6 or 7 requirements, have those been satisfied, and have any additional invoicing requirements in the contract been satisfied? If so, then it's a proper invoice. Or if not, and the owner doesn't speak up, it's going to be deemed a proper invoice. You don't look at if the owner disagrees with the actual value of the work, or say there's deficiencies, or the owner wants to assert a right of set off because the owner's incurred damages, maybe because of deficient work or delays or damage to property. That's more an issue of a notice of non-payment. That's more, I'm not going to pay you the entirety of the invoice, I'm only going to pay you half of it. but you wouldn't say the invoice is not a proper invoice on that basis. So it's more, a proper invoice is focused on the form rather than the actual, the quality of the work and the amount that's not being paid or not. Hopefully that makes sense.
Yeah, thank you. Another question is a supplier of equipment considered the same as a subcontractor in terms of when they get paid holdbacks from the contractor?
Yes, yeah, exactly. So a supplier of equipment, supplier of material, would be, is treated as a subcontractor. In the eyes of the Construction Act, there are only three types of people. There's the owner, the contractor, and then everybody else is a subcontractor. So all the subs of the contractor directly are subcontractors, all their subs are subcontractors, and the material suppliers are all subcontractors. So, and when we talk about prompt payment, or now the new annual release of holdback, when we talk about that payment cascade, that's all, everybody's paying the person immediately below them. And so, as a supplier, you'll be getting it, you'll be getting payments within that time frame of the person above you, whether that's a subcontractor or the general contractor directly. So, yeah.
Okay, thanks. And this one's a bit of a two-parter. So one of our attendees is looking for clarification that the decision as to whether or not design services apply to the act, so I'm inferring the Holdback Act, is up to the owner to determine. And then the other question is, what if the consultant provides contract admin and inspection services during construction? So would that be held back, or should be held that be held back?
So the easier question is the second one. If a consultant is providing contract administration services, definitely holdback should be retained. That it should not be controversial because the project has already started. And so in that case, a consultant who's doing CA work, they are providing services in respect of an improvement. And so the Construction Act would clearly apply to that. And so holdback should be retained from the owner's fee payments to the consultant. The trick is about the design services or consulting services before construction has started, because in Ontario, the way our Construction Act is phrased, as I mentioned, it doesn't talk about a planned improvement. It only talks about an improvement, which again suggests or implies construction has started. So it's created this ambiguity around, do people who have done work before construction starts, do they have lien rights? And so it's not that the owner decides whether they have lien rights necessarily. What the act is saying is that if the owner has made the decision to retain the 10% holdback from the consultant, then the Construction Act there's going to be a presumption that what the consultant has done are valuable services that have increased the owner's value in the land, which triggers their entitlement to liens and the obligation to retain holdback from them. And so the onus will be on the owner then they would have to prove in court that what the consultant did not enhance their value in the land. So it's more that owners just have to think twice about whether they're going to retain holdback or not. They have to just think clearly and understand the implications that by retaining holdback from a consultant, they will be, there's going to be this presumption that the consultant has supplied lienable services. I guess that's the best way to put it. And that so that if there is going to be a dispute down the road, it's going to be much harder for an owner to say, oh, you don't have lien rights, consultant. The court's going to say, yeah, but you retained holdback from them. So the presumption is that they do have lien rights, and it's going to be on the owner to try and prove that what they did not enhance the owner's value in the land. So I appreciate it's a bit kind of it's a little tricky there, but I think the bottom line is that owners need to just kind of revisit internally their consulting practices and their consulting contracts and all those various engagements. Who are the people we hire before construction, and should we, our practice of retaining or not retaining holdback from them, should we be continuing that in light of the Act's new changes?
Okay, thanks, Jeff. And just a quick note, it is 1 o'clock, so I know some of our attendees may need to leave. Again, we just like to thank everyone, and especially Jeff and Kathleen for joining us today. We'll continue going with these questions and maybe hang out for another 10 minutes to see how many we can get through. So I'll just continue reading off some of these. One is, for the annual release of holdback, is the owner responsible for publication or the contractor?
I believe it's the owner. Yes, the owner is responsible. That's right.
Thank you. This question touches on bonding a little bit. So if a contract price changes over the contract, does a contractor have to provide additional bonding? And do they get paid for this additional bonding?
Yeah, so yeah, a bit of a different issue there, but yeah, it's an important one. So generally, my understanding of I'm not a surety broker, but I think our understanding of how bonds typically work is that they will often be tied in some way to the value of the contract to an extent. And exactly the mechanics of that, I think, would depend on the specific wording of the bond. Often owners do want it to be clear, and you'll sometimes see owners put a provision in their construction contract that says if the price of our contract increases as a result of approved change orders, then contractor, you have to make sure that you're connecting with your surety to make sure that the performance bond you've provided me is increasing commensurately with the increase in the contract price as a result of those change orders. Now, in terms of whether that is a cost that is recoupable, that is, again, you have to look at the construction contract. You may also need to look at the Division 1 specifications in particular, because sometimes the construction contract will say in the change order pricing section, they'll sometimes clarify, what types of costs can a contractor charge the owner as part of a legitimate cost of a change order. Sometimes you can charge for increased bonding premiums and increased insurance premiums. Sometimes you can't. Sometimes the contract will explicitly say that will be deemed to be accounted for in your overhead and profit markup. So unfortunately, the answer is it depends. You have to look at the change order pricing terms in your contract specifically as to whether that would be reimbursable or not.
Thanks. Another question is, does the holdback release apply to only the mandatory holdback, or does it also apply to warranty holdbacks, such as in the case where contractor does not complete the warranty work? Can a notice of non-payment be sent and the warranty holdback not be paid?
Right. So all of this is only dealing with the 10% lien holdback. Warranty holdback or maintenance holdback is how it's sometimes referred to. Is a creature of contract. So that's a specific concept that would be set out in your contract, and none of this applies to that. So the rules about how you retain a warranty holdback, when it gets released, how you can apply it, all of that you would defer to whatever terms you've set out in your contract. So it's a great question, and it's important to just exactly distinguish between that and statutory lien holdback, which is what we're talking about here. So none of this would apply to warranty holdback.
Thanks. Another question is asking if it's the holdback mandatory for small projects. So sometimes the owner may decide it's not worth to hold it back, or they take on the risk of having to pay the subs without having withheld a holdback. Is the owner allowed to not withhold the holdback but pay any liens out of pocket?
Yeah, so holdback is mandatory. I know, folks who are getting their basement renovated or their deck finished, yes, may oftentimes do not retain holdback. So on smaller jobs, I appreciate it becomes administratively burdensome. But yes, no, technically, legally speaking, under the Construction Act, the holdback rules apply to every construction project, regardless of the size. Yeah.
Okay, thanks. Another question is, with the mandatory release of holdbacks, is there a partial substantial completion process being followed?
No, no, in the sense that there's no, there's no certificate of substantial performance. There's no assessment of whether, the contract has achieved a certain state of completion like you have in substantial performance. It's just purely based on the anniversary date of when the contract was entered into. Now, certainly, there may be disputes around how much work, the value of work that was performed and invoiced for during that year, and I'm sure we're going to see disputes over that. But there's no equivalent kind of substantial performance process for annual release of holdback.
Okay, and one last question here. This person has heard that there was a recent decision regarding liens and when they should be registered, which modifies a previous industry practice. So do you know any details on what that decision was, or could you point them towards it?
So that might be the decision. I can't remember the full name of the case, but it involves the town of Caledon. So you could probably Google that and it would come up. Certainly a lot of articles are written about it. And that I touched on it briefly when I was talking about the transition rules. And effectively, again, I assume this is what the person who asked the question is talking about. That decision, which was fairly recent, found that the transition rules, the Construction Act that governed the version of the Construction Act that governed all the contracts related to a project was all contingent on the procurement process for, in that case, the owner's engineer. And that's why it was such a momentous, very significant decision, because up until that point, I think a lot of people were not taking that interpretation. So the effect of that interpretation is that you could, again, have the Construction Lien Act, effectively, the pre-2018 version of the Construction Act, where it was the 45-day lien expiry period instead of the 60-day lien expiry period, applying to projects that are going on now, right? Depending on when you first went out to tender, when you first, issued for procurement your architects or engineers contract on your project. So I suspect that's the decision that we're referring to, and there's a lot of good commentary that people have written about that decision that they could find online.
Okay, perfect. Well, that brings us to the end of the question. So again, just really like to thank Jeff and Kathleen on behalf of OPWA. And yeah, we really appreciate you coming here and talking about this important topic. Thanks so much, guys.
Thank you.